Wasatch Report, shooting straight on everything from prepping to politics.
Good morning, everybody, and welcome to the Wasatch Report. I am Suzanne Sherman. I will be hosting in this next hour along with Greg Junkbond Carpenter is here today. Yay! Weighing in from Gay Paris, Jeff the producer, is here as well. Got three of us here today here on the Cerberus Radio Network, where we defend liberty and freedom from the flames of tyranny. We are just having too much fun. Hopefully we can get serious, kind of, sort of, before we get too far into this show, but we're having a hard time. You can follow us on Facebook, facebook.com/Cerberus Radio Network. CRN is our fan page. I want to encourage you to join. We're going to be shifting over our live discussions and commentary to the show. What's cool about that too is it can stay on there and people can join in if they listen at their leisure, if they can't tune into us live. By the way, if you can't listen live, you can go to our YouTube channel and or our SoundCloud channel as well. You can download all of our episodes on SoundCloud for free. Really, really helps as well if you share our announcements, if you share the shows. That way you can kind of get us established in this Facebook algorithm, and that really does help us out. Again, SoundCloud, YouTube, you can find those both on my social media bar on my website too, SuzanneCSherman.com. The radio network is, keep saying this, making our own website as well. But for now, you can see my articles, my blogs, and our shows on SuzanneCSherman.com. Speaking of articles, my latest from the 10th Amendment Center just came out. It is my take on the Bladensburg Cross. I do believe we covered it last week, but it is on our radio network pages, and I will also put it up on my website as well. Once again, I feel like the Maytag repairman. Everybody's cheering on the decision as a vindication for our First Amendment rights, our religious freedom, and it is actually another nail in the coffin for federalism and consent of the governed. We just seem to be hammered with all these claims of liberty being handed down to us by the federal judiciary, and that is absolutely not the way it is supposed to be working. Getting back to our announcements here, though, Radio Co. We have live Radio Co. streaming where you can hear our past shows. They're always timely. I don't just chase the news headlines. What is Trump doing today? I will be chasing a headline today. Actually, we got a really funny one out of Florida, but our stuff is timely. We really do focus on principles here. So you can have radio.co playing in the background. It is safe for work, safe for having playing when your kids are around. And in fact, they might learn something too. Certainly aren't going to learn the stuff that we're talking about in school as well. I also have an announcement. I've got Russell Sage. For those of you who follow Naked and Afraid, he is one of their hardcore veterans on that show. I think he's been in seasons 2 and 3. I have to make sure I'll put the episodes up. He's also currently right now on XL season 5. That is actually a 41-day challenge. And he just wrote a book. You can find it under suggested reading on my website, SuzanneCSherman.com. And order it. And that's an Amazon affiliate link. And that will help him out. And it will help us out as well. We spoke yesterday at length. He is a really, really cool guy. Funny. And he's also worked in the area of wilderness therapy for at-risk teens. So he had a lot of stuff to say. And I think he's going to make a fantastic guest. Kind of reminds me of a story I came across yesterday. Then we're going to get into the stuff right here. But man dies in absolute agony 10 days after eating a gecko on a dare. This is a little bit related to my announcement for Russell Sage. I came across this. He ate a gecko on a dare. And then I was thinking about a kid that did the same thing in Australia. He ate a slug on a dare. And both of these individuals died. So tying this into my announcement when we talk about primitive survival and wilderness survival, you can eat this stuff, absolutely. Just cook it first. That's today's PSA. Junkbond, thoughts?
Yeah, you want to know what you're eating before you put it in your mouth. I mean, better to be prepared and be ready. I mean, I spent almost 30 years in the Army, almost 20 years of that in the infantry, and we got sent to jungle survival school. We got sent to all these schools to learn what was edible, what wasn't edible. And too many times people make the wrong choice like this, and they get nominated for a Darwin Award.
And these
And
creatures
they're
all
eating snails. I mean, seriously.
what?
And he's eating snails. Seriously.
Snails are extremely bad. Yeah, there's different there's a bacteria of some kind in there that corkscrews into the brain, and if they're not cooked correctly, you will die every time. It's like guaranteed.
Well, and what I was thinking when I was reading this case, so we're going to move on in a minute, but again, I'd like to tell people anybody can end up in a situation where you're going to have to rely on what is around you, food or otherwise. So there was this kid again, and the 19-year-old, he had died after about a year.
Yeah.
He had severe brain damage, and
Yeah.
what you're talking about, the parasites. This is a worm.
Parasite. That's it.
Yeah, it's a rat lungworm. And what the reason I'm saying this is when I was in 6th grade camp, they were teaching us, we were out in the forest, Redwood Forest in Santa Cruz area, as a survival tool. If you ever get lost, they said, lick the slime off of a banana slug. It is full of protein. And some of the kids were doing it. I wouldn't go near this thing. I thought, you guys are absolutely crazy. Turned out my instincts were right. The teachers were wrong. Don't do that stuff. If you're going to do these things, cook them thoroughly. But it kind of ties into, again, the idiocracy of a lot of the public school teachers and the bad information they give us. So from licking banana slugs to our system of government, they just seem to screw it all up.
I will tell you one thing. I mean, it's easy to end up dead. It doesn't take much effort whatsoever. It's hard to stay alive, and you need to be educated, and you need to understand the situation you're in and not be afraid of it. Don't be scared. Engage based on previous knowledge and what you can glean from what you've learned in the past. You're not going to know the answer to everything, but you'll be able to make smart, informed decisions about survival if you understand and know where you're at and what's available to you.
Yeah, and I love talking about this stuff because, again, I don't care if you are just a city dweller. You're at some point or another going to have to go from one place to another and go through remote areas, whether or not you intend to spend time in them. And this stuff is completely relevant. Anyway, that's today's moral of the story, and we're definitely going to be talking about that more with Russell Sage. Junk Bond, you'll just love him, Jeff. He's just a really funny guy. Speaking of humor, this just out of Florida today, and then I'm going to get into a story that I did not have time to today from the book 3 Felonies a Day. We got into one of them, but this one is particularly relevant for me, especially as a former criminal defense attorney, because this really affects everybody as well. Again, I take these issues that other people aren't talking about, but try and tell you how this can really affect everybody. But getting back to Florida, here's the one. Remember the Rep. Frederica Wilson. I call her the rodeo clown. She says that those that are making fun of members of Congress, I mean, seriously, what else are we supposed to do? Should be prosecuted. Now, there's this little thing that says Congress shall make no law. Okay, never mind. So let's see. Here's what the story says. This is out of Fox News. I always go there for comedy relief, and sure enough, today was perfect. Democrat Representative Frederica Wilson said people who are making fun of members of Congress online should be prosecuted. She made the comments Tuesday outside the Homestead Temporary Shelter for Unaccompanied Children in her home state. You know, the funny thing is, they go to these places, and again, she's hiding behind the kids and coming up with something completely outrageous.
Right.
Those people who are online making fun of members of Congress, raise your hands if you are. My hand is so high in the air, are a disgrace. And there is no need. Check out the syntax, Junk Bond. You're going to love this. They are a disgrace, and there is no need for anyone to think that is unacceptable.
Wow. That's why we have public education.
Exactly. We're going to shut them down and work with whoever it is to shut them down, and they should be prosecuted. You cannot intimidate members of Congress, frighten members of Congress. It is against the law, and it's a shame in this United States of America. What law? What law is it against? To make fun of Congress. And if you find people making fun of you is intimidating or frightening, get yourself another job. Heck, she's already dressed like a rodeo clown. Go find some cowboys and chase the bulls around. What the hell is with this woman?
I'm shopping for shoes for her right now.
Yes.
They're big and red.
Find a little nose to put under those hats, too. So her comments came amid a controversy over a Facebook group that includes Border Patrol agents where they allegedly mocked and posted graphic contents about a member of Congress. I think she's upset that AOC is stealing her limelight in the stupidity front. But she also says that President Trump is responsible for this, for people losing respect for Congress. I did not know that before Donald Trump was elected that Congress had high approval ratings. Did you guys know that?
11%.
I remember it was like single digits.
Yeah, they were at 11%. It was a high when Donald Trump was elected.
So it's his fault because according to this genius, he has taken this country to its knees. She accused Trump of being hateful towards Black people and decided to not go to the State of the Union address in 2018. Her presence was sorely missed. I kept saying, boy, if only the cowboy hat rep from Florida were here. And she also rose to prominence again. She's just AOC stealing her limelight, so she's seeking attention. And I'm giving it to her.
She could have wore a white cowboy hat and a white duster, and she would have fit right in with all the other ones wearing all that white.
What a bunch of lunatics. So as you can predict, knowing me as well as you guys do, I'm going to make it my mission in life to make fun of members of Congress.
And you know,
she's gonna love you for
you're talking about this. Because she's like 200 and how many years? 19 years, 221 years too late. They already passed the Alien and Sedition Act in 1798.
Well, that's what Mike Maharrey said on my post. She can just use the Sedition Act of 1798 for model legislation.
She doesn't hold a candle to the original guys. And then on top of that, they already have what I had you look it up. What was that act? You have the code number.
Oh, yes. It's 18 United States Code 2385, and that makes it a crime to even teach about the need to violently overthrow the United States government, which, by the way, was created. The United States, well, this is before the Constitution, but obviously violence, we came from violence. No, we did not try to overthrow England. We simply wanted to leave. But you know what? They make it a crime. How convenient is this to even advocate the need to overthrow an entity that came about for what? Two reasons: common defense and essentially a free trade zone for the states dealing with each other. They've completely thrown off their restraints and then have a law that says, don't you dare advocate overthrowing us, a rogue, unlawful, illegitimate, de facto government. A little bit of my Crestlands Creek coming in there, folks. Hopefully
so we can't talk about secession, a peaceful political divorce. You know, we can't talk about Congress. They want to put us in jail for talking about them. Okay, first of all, I could have swore there was an amendment that said we could talk about stuff. But I'm wrong. Maybe I'm just making this stuff up.
Yeah, only some stuff against, for instance, according to Nancy Pelosi, you can't shout wolf in a crowded theater.
I'm really starting to regret the fact that I've called in from Paris today.
Yeah, and don't you dare leave, because we're going to need you for the other story I'm going to get into.
Good Lord, these people are complete idiots. I'm sorry.
Yes.
I just can't. I can't see anything else involved. I mean, think about this: to come up with ideas and thoughts about what they believe should be a law, and then call it a law, and then make us the criminals because they're acting like idiots. There's got to be like some psychosis associated with this.
Well, weren't you? I don't know if you were on the air with me that time, but I actually did an episode, and this was just on the heels of Mueller's little shot at encouraging impeachment of Donald Trump after he came out and did his speech, rather than picking apart his speech. And again, I sat there and took copious notes, and I thought, I'm going to cover this. I thought, you know what? Everybody else is talking about the same damn thing. And here at Cerberus Radio Network, we try to give you a break from the media, the mainstream media, we're going to hear. And as you've seen already today, from slugs to sedition, we got it all. Yep. So I did a show about
respond to something Greg said, because this morning, Greg, I posted on my page I didn't put it on CRN, our homepage, because it has crass humor and it has bad language, and we try to keep our shows and our Facebook page clean of so that kids can go there and go
G
there.
rating, baby.
Try to keep it clean so it's okay. But on my personal page, and I don't usually even post this on my page, I posted George Carlin on politicians, and he says, "Garbage in, garbage out."
Yep.
And he said, even if we had term limits, you just get another person that is just as dumb as the last person to take their place.
Right.
You got to go to I'll put it up on the fan page, because the fan page we're a little bit more liberal on. I'll throw that up there later after the show.
It's a very good political analysis.
He was an expert
all for
on
humor,
foreign
but
policy too, by the way. And anyway, the article that I was referring to was Mr. Sociopath Goes to Washington. These kind of positions attract sociopaths. They attract the people that desire to control others and take extreme advantage of that monopoly on violence and the control that they have. And this goes down from the local, PTA, homeowners association on up, which is why I totally agree with Mark Crescens and all of us here. No government, no legislatures. We just want a minimalist government that does what it's supposed to do. And this gal here, oh my gosh, when they act like clowns like this and want to put people in cages for calling them on that, absolutely insane.
I'm glad we'll never have more politicians like that again.
Right. Thank goodness.
So yesterday, basically, I basically said what you just said, Suzanne. I said that I would oppose any form of government that included a legislative and executive branch. If we ever achieve peaceful political divorce, I would make sure that all laws and all taxes have to be passed. Well, Mark says 100%. I was being kind. I said it has to pass by a 90% supermajority. And that way it would make it practically impossible to pass taxes and pass laws. Because having a legislature just means that they're there 360, well, not quite 365 days a year, because they're always on vacation.
24 days a year.
They're too much as it is, passing laws because they feel that they have to, because they were elected to pass laws. And I totally reject legislatures now.
And the reason we have all this contention is because we have, and I say this all the time, we have abandoned our founding principles that we were supposed to have sovereign and independent states that were responsible for their policy, social policy, and decision making. Again, everything that was not delegated to the general government remained with the states. Because we have completely inverted that system, every single policy issue is now one of national contention. And what is the result of this? Again, I was on a radio show one time where the so-called conservative host, again, love him dearly, great friend, but this just shows conservatism really doesn't mean much, because the question presented to me was, how are we going to have or avoid fighting in the streets without the Supreme Court to tell us what the law of the land is? My response to this person, well-intentioned as they were, was, it is precisely because of the Supreme Court telling us what the law of the land is that we have fighting in the street. Case in point, let's talk about Portland for a
second. Before we move on, I got to go to the live chat.
Oh,
I can't let these people talk and not
bring him in. Bring him in.
All right, so I'm going to give his last name because he was a guest host last week, and so I'll give his name. Justin Spears. Tom Woods, law
that
number
would be
3.
His full name, not just his
Hi,
last
Justin.
name, Jeff.
Hi,
Yeah.
Justin's out here. Hi, Justin. Anyway, Tom Woods, law number 3. No matter who you vote for, you always get John McCain.
Yep.
So there you go.
That's a very good analysis, too, by the way, if you think about it. Using the system where you only have one option or the other, as in the George Bush, you're either for us or against us.
Yep.
You can create very strong polarization, and therefore the John McCain model is extremely powerful, because everything that was totally unbearable, you were against it. But something that had even just 1% truth or honesty inside of it, you had to be for it. But by doing that, you inherit the 99% of garbage that goes along with that. Therefore, you have a push towards the negative every time you embrace that 1%, 2% of goodness that you have to try to put in, because what do politicians do? I can't believe you voted against the children here. Well, it was attached to 98% bullshit. Yeah, but that's okay. Nobody will ever look at
Potty
that,
mouth.
right?
Potty mouth. And that's
Oh, well,
and that's also how they frame the questions and surveys that you get all the time as well, where the questions presented to you in a manner that you can't answer it in a way that would advocate limited government. For instance, I was called regarding policy formulation here in Utah with regards to caregivers, people that are caring for elderly or disabled folks within their home. Do you think caregivers should be given support? Well, yeah, but I can't answer that because what you're proposing here is support by the government. Clearly, caregivers should have support, but by their family members and their community. What you're trying to do is take money from my pocket so I can support somebody else. And then you want to make me feel like crap because I disagree with that. Oh, but these people need support. Yes, they do. That's where community comes in. It comes in proper role of government. Again, when government gets involved in these things, everybody complains and gets upset. Let me share really quickly with you, and I'm writing an article about this one, but I saw this last night. Jeff and I weighed in on this. I'm going to take about 10 minutes here because we do have time today between all of our shenanigans going on. I am known for being the lone naysayer, one of the few out there when everybody's cheering a decision. I'm the one peeing in everyone's Cheerios going, this is not a good thing. So going back to the that's not a good visual. I'm so sorry. there's the Gay Baker case in Colorado, vindication for his religious freedom. No, it isn't, because it came from the Supreme Court, and this was clearly a case that was never delegated to them and should have been handled in Colorado. What Kennedy did, the primary author of Obergefell, by the way, said was, if you do this in a manner, wink, wink, that doesn't appear to be biased against religion, meaning if you do it in a neutral manner, we're going to support this. So here's the keys to the kingdom. Here's how you can shut this guy down. We're going to tell you how to do it. And I'm telling people this is not a victory at all. Same thing with the cross, the memorial in Maryland. Everybody's saying that was a vindication. And this was something that the founders would have agreed to. I talked about that. And I said, no, once again, we have to look at trying to avoid having our liberties protected by the federal judiciary. Amy Coney Barrett strikes a blow against campus kangaroo courts. Am I supporting what the campuses are doing? Absolutely not. Her opinion holds universities legally responsible for their woke ideology. Again, some of the biggest thinkers I know, the people that I respect the most, are cheering this on. Thank God for Mike Maharrey and Mike Bolden, or I would think I was absolutely stupid here. But here, whenever I read a court opinion, this is out of the National Review, hence their perspective. I read a court opinion describing a campus sexual assault proceeding. I routinely find myself shocked by the staggering unfairness and ridiculous bias of campus kangaroo courts. Driven by the need to find more men guilty and rationalized by a believe women ideology, campus administrators have systematically discarded every fundamental notion of due process in American law. So this is what they said here. Now, they're blocking biased sexual assault adjudications. The courts are doing this, protecting basic fairness, restoring the degree of sanity to colleges' procedures. Sounds good, right? But here I am in the background going, wait a minute, back up the truck. How is this a federal issue? Even Dwayne Stovall said, come on, sister, get with it. Due process. Due process from what? Oh, check this out. On Friday, it was the turn of the Seventh Circuit Court of Appeals to protect the 14th Amendment.
Mm.
The 14th Amendment, which, by the way, was never legally ratified. It was passed by joint resolution. Due process clause, remember, the 14th Amendment was only intended to provide basic citizenship rights of freed blacks. It was never even intended to apply to states that weren't discriminating against them. Read Raoul Berger's book, Government by Judiciary. If that's too heavy a read or you don't want to take the time, you can knock out Dave Benner's book, The 14th Amendment and the Incorporation Doctrine, in less than an hour. It sums it up. The 14th Amendment has been the means by which the federal judiciary has systematically dismantled our system of limited government and federalism. It has turned us into, by judicial fiat, one United States of America with 12 black-robed messiahs decreeing what the law of the land is. The facts the article says here are extraordinary. You can read it. I'm going to post it. It is already on my page in the Wasatch Report page. Yes, the behavior is egregious. And here's the kicker. This is all college procedure. There are no criminal penalties imposed. Yes, they can be life affecting here because the student that was vilified and the victim of their policies at Purdue, lost his Navy ROTC scholarship and was expelled from the ROTC program. This is egregious. Once again, the forum for redress is not the federal judiciary. But here's the thing. Everybody's got their own dog in the race and they want to protect that. Just like with the Bladensburg Cross, Kevin Gutzman. It's a constitutional question. Me. No, it ain't. Yes, it is, because they filed in federal court. We had a conversation about this, and he said if somebody punches somebody else in the face, they can file a suit in federal court saying it's a constitutional violation. My hands are in the air. If that is a constitutional question simply because somebody says it is, the Constitution is worthless because there's no limiting what the federal judiciary can regulate in our lives. As Lysander Spooner said, it was either designed to operate the way it is now or it is powerless to stop it. Thoughts, gentlemen?
I think you hit it spot on. Lysander Spooner said it exactly right all those years ago. And I was a big fan of some of the things that he wrote about the Constitution. I've read quite a bit. You'd be happy. I'd get another cookie. I guarantee it. Yeah. Oh yeah. I'm gonna be cookified.
So wrapping. Go ahead. I'm sorry.
You really, but you really. I mean, we really need to think about that point. I mean, he said so much more in that statement than we consider nowadays. It was either designed to do it based on, and you could base it on George Mason and Patrick Henry's analysis during the Virginia ratification debates, where they called out everything that was going to happen and saw it happening. Even John Adams said, you've got a democracy. I think it lasts 150 years at best. And I'm paraphrasing, folks. Don't kill me over this, but he saw it fall apart by 1938. We really need to understand that it either was designed to entrap or it was completely powerless in defending against it. The Articles of Confederation, being much more decentralized, would serve a much better purpose in maintaining autonomy at a lower level, meaning that the states would have more power, the communities, the towns, the counties would have more power, and the federal government was almost powerless to do anything other than just a few tasks which was authorized. That would have been a much more better plan of government if you were going to maintain autonomy of the people. But that didn't happen, obviously.
Marshall DeRosa wrote a fantastic book on the Constitution of the Confederated States of America. I highly recommend people read that one too. A lot of the problems that were present in the United States Constitution were addressed in that one. I think I'll put that book up, the Amazon link, on my website as well. But here's wrapping up this story here. Judge Barrett was unsparing in her criticism of the university's procedures. And to that I say justifiably so, but not from a position on the bench of the federal judiciary. From that position, Amy, it's none of your business. But when does the federal judiciary ever say, you know what, that's for the states to decide? Or sometimes what they'll do is say, yeah, that really is for the states to decide, but we're going to do it anyway, like Scalia did in his concurring opinion in McDonald. Another case that is celebrated as a gun rights victory, which is not. So again, when we look to the federal judiciary to protect our liberties, we are putting faith in the one entity that has been overwhelmingly responsible for taking them away. I don't understand why people cannot let this go.
Because it challenges their beliefs and value system. Everything that they had been taught when they were incorporated into the public education system has, will be completely nullified if they accept this completely different belief, which obviously has different values with it. It's not easy to change people's systems like that. And you really have to reach out and help them understand as much as possible. That's why it's hard. Even the people that we look to and we look to for advice when things are bad like this, still sometimes fall back into that trap and say, oh, okay, you know what? Yeah, it is a federal issue because of something that's completely ridiculous.
Yeah, and all you have to say is, well, this cross violates the Establishment Clause. Well, okay, but the Establishment Clause doesn't apply to state-owned land, and know that clause is not on federal land, and that's why I kept asking on the comments when this was being discussed, who owns the property? It's public.
Right.
I know that. Which public? When you say public, it just assumes that the Establishment Clause applies to all public land.
Right.
So I was going to say something else. I forgot what it was. But we're going to get into now another case. Again, when we look to the federal government to protect our rights, we have to, again, understand that they're the ones responsible overwhelmingly for violating them. And this is a story I wanted to get into yesterday. And again, a direct result of federal government overreach and absolutely ignoring their constitutional restrictions. Also, the case with Amy Barrett was the justification for them getting involved was not only the 14th Amendment, but Title IX. And that's, again, where's the constitutional authority for Title IX? It ain't there. It ain't there. But this is a really interesting case. And this is Chapter 6, a segment of Chapter 6 in the book, 3 Felonies a Day, How the Feds Target the Innocent, by Harvey Silvergate. I'm going to put this also on the website if you want to read this book. It is very enlightening, very frustrating, but summing it up quickly, in the eyes of the federal government, we're all criminals. This is a chapter, Lawyers, Government Offense Against the Best Defense. And what's particularly scary to me as a criminal defense attorney is how easily we can be dragged into the federal web of criminal behavior by virtue of being a competent and zealous advocate on behalf of our clients. I'm going to give you briefly the facts of the case. On October of 2006, a church employee at a church in Connecticut was discovered to have been storing illicit pictures of children, child pornography, on the church-issued laptop computer. That's why I'm glad you're here with us, Junk Bond. We can talk a little bit about cybersecurity, what the legal issues are with regards to these issues, and laptop computers and data. The church sought legal advice from a local attorney by the name of Philip Russell. He recommended that the employee be immediately terminated. And on October 9th, the attorney, Russell, took possession of the laptop and destroyed the hard drive, which contained images of the naked young boys. Most lawyers, and I will say this, and they said this in the book, would have done precisely the same thing because on the theory that the law allows and even requires the destruction of contraband or material considered harmful and illegal for anyone except those in law enforcement to possess under any and all circumstances. Dealing with contraband for us lawyers can be very tricky. And the very act of possession, they compare this to heroin. The very act of possession is against the law. Child pornography is in the same category. I remember a story where somebody actually purchased some marijuana from a street dealer, turned it into police, and they themselves were arrested for having the marijuana. Serves them right, in my opinion. So what was the attorney to do? Should he take possession of this pornography, child pornography laden hard drive and hold on to it? If he did, he's committing a serious felony. Or should he turn it in, thereby incriminating or betraying his client? Remember, we as attorneys have an obligation of confidentiality to our clients. Otherwise, they're not going to be truthful with us. These are difficult choices, and he decided to destroy what the law considered contraband. The author here, and I agree, says that this was a defensible and even an honorable decision. Now, here's where it gets a little dicey. Unbeknownst to Russell, the attorney, 3 days earlier, the feds had begun to investigate this employee, the former employee. They had been tipped off to the individual's involvement in child pornography, and the U.S. Attorney's Office considered the computer hard drive to be evidence in investigation. Remember now, Russell had no idea any of this had transpired. He was charged with obstruction of justice and destruction of evidence, a felony that carries a 20-year maximum prison sentence. In February of 2007, the indictment did not claim that he knew at the time he destroyed the images that they had begun the investigation. The prosecutors even acknowledged Russell destroyed material that was illegal to possess, but they still indicted him. So think about this. What would you do if you were the attorney? If he hangs on to it in case the feds might be interested in this someday, let's assume they hadn't started the investigation yet. He himself is going to land in federal prison. Damned if you do, damned if you don't. The independent bar, this is talking about lawyers, like us or not, have been a bulwark against government overreach, the book explains, and official repression since the founding of the Republic. And as I'm reading this statement, I was thinking of the example they just listed right as I was right as I was getting to it. They used the case of John Adams when he represented the British Redcoats in the Boston Massacre. America's lawyers, they say, as a profession, are more directly involved in opposing certain governmental goals. Think about the ACLU representing our good friend Michael Meharry. He's being sued by Lexington, Kentucky for having the temerity to seek information as to why they have all these cameras up and are spying on the citizens of Lexington. He's getting sued for his efforts. Thank goodness the ACLU is stepping in to help him out. Otherwise, he could go bankrupt. So what they do is they have a chilling effect on questioning their behavior. A prosecutorial assault on lawyers, they say here, who are essentially just doing their jobs, is a matter that is of particular concern to a free society. Absolutely, absolutely. So here they talk about the trial judge, Alan Nevis from the U.S. District Court for Connecticut, let the indictment stand and ordered him to stand trial. Think about how much it's going to cost an individual to be represented in a criminal case in federal court. Russell was charged under two lesser-known provisions of the Sarbanes-Oxley Act of 2002. Once again, now he's being charged in federal court for the commission of a federal crime by an unconstitutional act. I say it time and time again. What are the 3 and only 3 crimes the federal government was authorized to deal with? Piracy on the high seas, counterfeiting, and treason. Congress passes an act, and it is a de facto constitutional amendment without consulting the states. So, he was charged with violating this act, which supposedly was designed to restore investor confidence. Jeff, can you please look up investor confidence restoration under Article 1, Section 8 while I continue on here? It was designed to restore investor confidence in the wake of the Arthur Andersen corporate accounting scandal. And Section 802, criminal penalties for altering documents, and Section 1102, tampering with a record or otherwise impeding an official proceeding. These are obstruction provisions broadened the obligation to retain documents so that a party could not destroy them.
Did it include the awareness?
No, they don't want to do that. If they want to take that element out, they don't have to prove it. So, contemplation of a future investigation, even if no formal investigation had begun. As I'm reading this, please tell me how Hillary Clinton is not in leg irons for turning in subpoenaed evidence that had been smashed with a hammer. Crickets.
Because she's Hillary?
Yeah,
You're not going to hear anything.
Laws are for thee, not for me. Judge Nevis concluded that it was unnecessary for the government to have specified in the indictment that Russell had in mind any particular investigations, or that his intention was of obstructing or interfering with any official proceeding. It would be up to the jury to read his mind.
Wait, so are we saying that this is an act of conscience?
And as I discussed yesterday,
it's a thought crime. It's a thought crime.
As I discussed yesterday, you have to have a combination of the guilty mind and the act. Actus reus and mens rea. I inverted them, but that's what you have to have. We discussed this. So they revised this law. And again, they said that this language was vague. Now, we just had a case where Gorsuch was accused of siding with liberals because he said that a law was unconstitutionally vague. Kavanaugh sided with the conservatives for wanting to put people in cages. Are we starting to see a pattern of how ridiculous looking to the black-robed messiahs is? And we don't even know what conservative and liberal is. When the government gets involved in all these areas, it's so convoluted, and we have to pretty much make it up as we go along pertaining to each particular case. So here, the revised language, wrote a writer said, implied that people could face criminal charges by tampering with documents before they become evidence in a federal investigation. So here he's faced with the implied responsibility of hanging on to contraband in case the feds ever want to use it. He's just doing his job, and now he's subjected to criminal prosecution. The other problem with this is this implies, or this interposes, an inherent conflict of interest between an attorney and a client, and we are told we need to avoid this. So, in determining whether or not this attorney is going to continue to assist this church, he has to think, well, do I turn over evidence? Do I turn over contraband that was entrusted with me in the course and scope of representing my client? Or do I hang on to it in case someday the federal government may want it? Either way, I'm going to jail. So why do people even want to get into criminal defense in the first place? Puts us in a very, very tricky position here. It's very precarious because if you get it wrong, you're going to the federal penitentiary. The operative issue for the criminal lawyer is to decide what's evidence and when does something become evidence. How prescient does a lawyer need to be? If you get it wrong, you've got big problems. Again, I'm asking myself as I'm reading this, where did the federal government get this authority at all? Because here's the inconsistency of the government's position. They cannot argue both simple possession of child pornography itself victimize the children and yet criminalize the termination of victimization by destroying the images. It is as if the primary purpose of the criminal law is to create prosecutions. There it is. That is exactly the purpose of it. The vagueness of this statute, as it was used in his prosecution, raised another problem. An attorney, historically, there was a provision. Let me back up. This was highlighted by a remark made by the Associated Press, a reporter by the name of John Schoenhorn. He's president of the Connecticut Criminal Defense Lawyers Association. And I get it. You know, we lawyers are not exactly sympathetic targets here. We're not a sympathetic class of individuals, particularly as criminal defense attorneys, until you need us. By the way, he focused on the perversion of the attorney's historically understood role as a trusted legal advisor to his or her client, as I alluded to earlier. The most troubling aspect is the statute tried to make lawyers shills or handmaidens for police and government investigators. In other words, anything that the lawyer does that makes the prosecutor's job harder is seen as a crime. Local criminal lawyer, another lawyer, Lindy Urso, put it best when he told a reporter, "I don't like to consider my own interests when I am defending a client." He questioned whether the statute encourages us attorneys to weigh protecting their clients or themselves. That's the inherent conflict of interest I was pointing out. This whole thing is really encouraging lawyers to become nothing more than lapdogs to prosecutors. To the prosecutor, in this case, there was no lack of clarity in the statute and no perversion of the attorney's role. The statute, he explained, does not require corrupt intent. So simply doing your job with no intent to cause any kind of destruction of evidence or harm whatsoever will land you in this kind of hot water. Federal law does not make an exception for such possession by defense lawyers and experts. Under circumstances such as these, it is hard to fault Attorney Russell for destroying the computer drive. What do you do at this point? So he eventually entered a plea bargain. The indictment under the federal statute was dismissed, and he pleaded guilty instead to a lesser charge of misprision of felony. Misprision of felony forbids concealment of knowledge of actual commission, I beg your pardon, of a felony. It's potentially troublesome for attorneys as the obstruction provision of the statute has been judicially interpreted to require some active element of misleading investigative authorities rather than failing to simply report a crime. So if you don't report a crime now, this is misprision of felony. This is a very slippery slip, and I find this very problematic. The author goes on to say, but when the lawyer is representing a client with whom he has had a relationship characterized by long-standing legal principles of confidentiality and loyalty, drawing that line can be extremely difficult, if not impossible. And neither the Supreme Court nor Congress has lent much clarity to the matter. And my interjection there is, nor should they. Even though it would have signaled a revolutionary change in the definition of the attorney-client privilege, the application of the misprision statute to this situation went unquestioned because it was part of a plea bargain aimed at averting a more serious charge. If anything, it is an essential part of a lawyer's job to lawfully withhold information from prosecutors. Remember, who has the burden of proving and establishing guilt beyond reasonable doubt? The prosecutors, every single time. It's really interesting the way they like to relieve themselves of that burden of saying you can infer certain things, or, certain facts, by the way, are proven. The jury has no choice but to convict. To that, I say jury nullification. You have an obligation to refuse to convict if either you find if you find one of the two applicable. Either the law on its face is unacceptable to you, it's repugnant to principles of liberty, or it is repugnant to principles of justice and fair play as applied. And you as a juror have a right to do that. Jury nullification. Chuck, did you want to contribute?
Yeah, I did have a question. I mean, the lawyer was convicted, right? He was prosecuted on a lesser charge.
He had a plea bargain of misprison of felony. So,
Right.
so
okay,
again,
so the objective was achieved.
Mhm.
Yeah,
Yeah,
because they got a conviction out of it.
Yeah.
Yeah, they couldn't get the guy on the pornography stuff because it was gone, but they still got a prosecution out of it because they were able to convict the lawyer on doing his job. Now, it's interesting because in federal IT, if you come across any child pornography or anything like that, you have to immediately turn it in, and it gets turned over to federal law enforcement and stuff like that. But this is a private case. It's completely different, and I find it very interesting because think of the feds, like in the Department of Defense, you have to turn in any child pornography. So it's like a big company. So it's a corporate policy that says this is what you have to do, right? So there is something in place that requires other employees to follow through with an action. Here, the lawyer has to make a decision, which they would do with anything of this nature, on how to deal with the situation and to work with the client as they should. I think they made the right decision. This lawyer, it's the same thing that I think some of the other lawyers that because working in IT, have come across, and they've done exactly the same thing. I'm surprised they're all not in jail right now for doing the right thing. But it makes absolutely no sense, and I think that you're absolutely right. The objective is to put people in prison or get convictions in one way or another. It is absolutely nothing to do with justice at all.
And again, there's absolutely no lawful constitutional justification for these federal statutes under which they are punishing him. That ties also into Amy Barrett's lawful authority and the Seventh Circuit to weigh in on what is the internal behavior of Purdue University. But again, they cannot help themselves. Always subverts the will of the people. We were talking about that with some of California's laws on yesterday's show. Do I approve of what was going on at Purdue University? No. But at some point, how about people stop applying to these colleges? There was another article I came across that was posted where it said that it is going to be up to the colleges to fight all of this unfairness. I don't have the article in front of me, but I just started laughing. Like, you're going to see somehow it's going to be up to the colleges to fight this mentality that is up at Purdue University. The people that are going to these universities have already been indoctrinated through the K-12 education system. And then you get away from home and you're surrounded by Marxist professors and academics. Nobody's going to have the temerity to stand up and fix this. Certainly not the tenured professors who get away with this stuff. I remember, I've shared this story before. I had a FDR lover, Robert Dallek. He's a very well-known historian as a history professor at UCLA. And the class that he had 500 people in it. So we'd have this class where we'd hear his lectures, and then we would have the discussion groups. But in one of the rare times he accepted questions directly from the students, somebody raised their hand and asked for his commentary on the John Birch Society. And he puffed up his chest like a big stupid pigeon and got this smug grin on his face and just proudly proclaimed that there is absolutely no room for discussion about the John Birch Society, an institution of higher education. And all these idiots in the class cheered. And I'm looking out. If that had been me today, I'd have had my hand up next and I'd have said, why? We're here to learn. Isn't learning the process of learning? Doesn't that happen by examining and exploring positions that may be different from your own? Nope, not according to this guy. There's no room for that discussion. And it's only gotten worse. But does that mean, with regards to the Me Too movement and all the crap going on at Purdue, that it's the role of the federal judiciary? No, it is up to us, we the people, to say, you guys are full of crap. We're not sending our kids to you. In fact, we're not even going to sentence our kids to a 12-year prison sentence in your public indoctrination centers. We're going to simplify our lives, and we're going to personally secede. You guys are on your own. And see how long this crap lasts. Thoughts?
Sadness.
Well, talk about the personal secession all the time, that we need to take responsibility, adjust your priorities, and if need be, downsize so that you can put your treasure where it belongs. And if your children are important to you, which they should be, and I'm sure they are, do what's necessary to get them out of the indoctrination camps.
Let me share with you, as we wrap up the show, another example of the folly of turning to the black robe messiahs to protect our liberty. This was from the Rutherford organization. And the article is pure incorporation doctrine, but it does share some information, again, as to the folly of turning to the federal judiciary, particularly what our good friend Brian Balcom calls the judicial temple monkeys, in a ruling that gives police greater leeway to violate the Fourth Amendment rights of anyone driving on a public road. The United States Supreme Court has ruled, here's your freedom-loving Supreme Court, folks, that police may forcibly and warrantlessly carry out blood draws on unconscious drivers suspected of drunk driving. Next. 5-4 decision, Mitchell versus the state of Wisconsin. Again, incorporation at its finest. This is what happens when you roll the dice with the Supreme Court, folks. It will go against you. With regards to the cross, Kevin Gutzman said that, well, if Ruth Bader Ginsburg had her way, crosses would be taken down at Arlington and all around the country. And I said, then why roll the dice and go before them? Everybody was sure that the Affordable Care Act would be rendered unconstitutional. What did Roberts do?
Capitulated.
Exactly. But people keep running to the federal judiciary. Incorporation is my thing. I will hammer on this every single time I see it. So they go to the Supreme Court. The Supreme Court says, if you are suspected of drunk driving and are unconscious or otherwise unavailable to give consent, we are going to stick a metal object in your arm and draw your blood. And we are going to say that that is okay across this continental landmass. And people cheer on this very same entity when they rule in a manner they like. Be consistent. Never accept a ruling from these people when they don't have the jurisdiction according to the Constitution as ratified. Whether you like their decision or not, you are playing into the hands of the bad guys. You are saying we are incapable of self-governance. You are saying we don't want a representative form of government unless you consider one justice, one lawyer for over 32 million people. If that's your idea of representation, please, can we secede? I would like a state that doesn't look to this. And if there's a state that wants this, that wants all this coming out of Washington, D.C., they can have it. If there's a state that wants to ban gay marriage, they can have it. If there's a state that wants to have it, if there's a state that wants to ban guns entirely, we all have somewhere to go if we respect federalism and limited national government. But what these people are doing, primarily what is so disturbing, the people that are supposed to be the most vocal, educated voices in favor of limited government are cheering these people on. It gets very discouraging to me, folks. There's our music. I wanted to end this on a high note. Happy Independence Day, everybody. And we'll be back on Friday.